There we go. We'll do that too. You scroll down to the bottom and it has view adopted form changes. So if there's any questions about any of this, when you go into that one, and again, we went to legal and ethics, we went to form changes. That'll get you right where you need to go. Go to adopted revisions. And here's all the contracts that changed on September the 1st, all the forms that changed as of September the 1st. So we have the 1 to 4 family, new contract, income, new home contract, incomplete, complete, condos, commercial, farm and ranch. And then there's some addendums in here. There's an addendum for a public improvement district, that's the new addendum. And if you know that the property is in a public improvement district, that addendum applies. And that's what the change was to the contract. So the legislative staff or legislators made changes to the laws for the state of Texas, and TREC issued these out as an emergency. Let's get this out because it's required by the state now, right? That's how all this came about. There's a couple other little things in here. When you look at these, when you open them up, what these are, they're the red, what they call the red line version. And give me just a second. The red line version is where TREC made the changes. So this right here is where one of the changes was. And what they did was they took out the red and added the blue. So seller must give the buyer a written notice as required by state property code. You'll hear me use that later on again. State property code is pretty important. That's what TREC reacts to. And the addendum containing the notice shall be attached to this contract, attached to the contract. That means it should be with it, right? Not if we feel like filling it out or any of that good stuff. There's a couple other changes in here. One of them was residential service contract companies are no longer licensed by TREC. That was one of the legislative changes. But the main thing that we're focusing on, and the reason all the contracts changed, is this right here, where it's talking about the improvement districts. And that's what the new addendum is about. We're not going to cover that in a lot of detail, but know that it's there. There's a video I posted in the Facebook groups that covers some of that, so that should be okay. We should have that taken care of. Those forms again are available through Texas Realtors. And you can also get them on TREC's website, which when we are on TREC's website, if we go to TREC and you go underneath agency information, can you guys still see that okay? Agency information, you go to contracts. If I click on contracts, the new contracts are here, right? And these are all the promulgated forms, all the promulgated contracts. When I click on the specific contract, whatever it is, that's the new contract. Red line version, 3014 and then 3015. 3015 is the most recent on this specific contract, right? 3014 is going to be the old one where they made all the changes about the paragraph 4 and 8 and all that stuff. And it's that way on all of these. If you are trying to learn contracts better, you can do the same thing on any one of these. You can go in and click on it. There's 2015 on residential. That's the old one with the changes. And then 2016 is the new one. And again, the blue is what they added, red's what they took out. So if you're trying to learn them, that might be one of the ways to do that. Any questions there? Right.
No.
Yes.
No, I mean, like, no questions. I'm sorry.
Oh, okay. No problem. All right. So I'm going to go ahead and continue with this. And what I'm doing here is I have some highlighted forms and I just want to cover them. And let me see just real quick. So I've not done this in a while, but in the Dropbox is that all the forms that I'm going to show you today highlighted. So you'll have exactly the same thing that I'm using. So you can use that as a reference. I'm going to just cover some of these. I have highlighted certain things in this. Information about brokerage services. All of us know how that works. We all know how it's supposed to be presented. We know that we actually need to actually present it, not just give it to them, tell them to read the darn thing. We don't want to do that. We want to talk to them about it, right? Who can answer? What does this form actually do for the consumer? What are we supposed to tell the consumer with this form? What is it telling them they have?
Options.
Voice in the back of the room here. Anybody?
What form are we talking about, Mac?
Oh,
I'm not seeing it. I mean, all I'm seeing is there we
there you
go.
go. There you go. Information about brokerage services. Thanks, Candy. Yeah. A few moving pieces. So when we talk about the information about brokerage services, TREC wants us to make sure that the consumers know that they have options. They have choices to be represented or not to be represented, right? They have that choice. And that's a part of what this is about. And that's why I have the items highlighted that I do. And I use the highlighted part myself even to let consumers know that if I'm representing the buyer, everything they tell me is going to be confidential. However, if they tell somebody else, it probably won't be, right? And that if I'm not representing the buyer, and this is the one part on this form I absolutely love, if I'm not representing the buyer, then I'm representing the seller as a sub-agent, and everything they tell me will go to the seller. So representation is best. I'm sure you would agree. You probably want me to be your agent, right? Yes. Okay, good deal. Oh, ready to go. On this form, right here at the top of this, and some of you in one of the other offices recently going through some of the forms, my note was first line should be Remax Elite. So it's the broker firm name or the primary assumed business name or licensed broker. Broker firm name is Remax Elite. Everybody should have Remax Elite there. The license number for Remax Elite is going to depend on how that's set up for the different offices. Because Remax Elite is the DBA, it's doing business as, right? That's the firm name. The designated broker is going to be Norma Hinojosa, right? That's the designated. You only have one designated broker. And just recently, and I'm not sure why, I've started seeing other people's names in there. And if you go to TREC and you look at your record, you'll see who is your sponsoring broker. That's the designated broker. That's the name that needs to be there. And all of these lines need to be filled out. If you don't have anything to go in there, like on mine, for example, the very first one for email, for Remax, I'll have the Remax, the license number, and email. I have NA because there's not an email for Remax Elite by itself. There's one for the broker, there's one for the supervisor, there's one for the agent, but not for the company. And that I've used that example several times. The other thing I want to touch base on, and there's only one office that's doing this, so I know it's specifically for them, without naming names, but right here where it says buyer, tenant, seller, landlord, that means like buyer or tenant or seller or landlord. It doesn't mean we have buyer on one side and seller on the other side, and we have two sets of initials on here from two different people. This form is designed for your customer client, right? Not everybody else's. And if I'm talking to a buyer, I do one with a buyer. And then if I'm talking to a seller, I do one with the seller. I don't do the same one with everybody involved in the party. And by the way, if they're from ABC Realty, we don't need theirs. We don't need it. And if they send it to us, we might want to just send it back to them, tell them, hey, I'm sorry, we don't need this. We don't need additional documents in our packages. I could be wrong, but I'm of the belief that the more paperwork we have, the more options somebody has if they want to complain. Because remember, everybody's supposed to get copies of everything they sign or initial. And if I give them a copy of somebody else's document, my buyer, for example, a copy of another broker's IABS, that could open up some issues, and we don't need to do that. Next form is general information notice to buyers and sellers. Everybody should be using this form. Everybody should be using this form, especially with buyers, I have highlighted on it. Again, it's in the handout. So you can grab it from the handout. But I have highlighted certain things on here. Like, for example, both buyer and seller will be provided information about brokerage services. If you cover the general information, notice the buyer and seller, you've covered just about every possible base there is, if you'll cover the items that are highlighted. Now, there may be some others depending on what's going on with your particular buyer or seller, but the items that are highlighted are pretty important. Like, for example, that each one of them will get an information about brokerage services. We have an obligation to negotiate the transaction, and we're not inspectors. Also, if there's lead-based paint, we need to make sure they get a pamphlet. That pamphlet is in zip forms. It does not require them to initial it. They acknowledge on the lead-based paint addendum that they received that pamphlet. When there's a spot on the lead-based paint addendum that says they've received that. So when that box is checked and they sign it, they've said they've received that. But this gives us a chance to let them know that if we have a home like that, we're going to provide you with this pamphlet. That's just my take on that. FERTA, something we should be talking to everybody about, especially on the listing side. Make sure the buyer side is aware of it. Everybody knows that if the property sells, if the seller's selling the property and they're a foreign national, the buyer is responsible, is what the contract says. The buyer is responsible for making sure that the money's withheld. So why is that important? If you go to if you go to Texas Realtors, if you go to their legal frequently asked questions, one of the questions in there is, if I represent the buyer and this doesn't happen, could I have some liability? And of course, the answer is coming from attorneys, but it's probably. Right. So if the money's not, if I'm representing the buyer and this is not done properly, could I be responsible for it? And the answer is probably. Right. So we want to make sure we talk about that, especially on the listing side, to make sure it gets documented. And I touch base on this one because I've seen listing agreements where this paragraph's not marked. It's in the listing agreement. And if it's not marked, I believe, and I could be wrong, but if it's not marked, I believe the listing agent probably did not have that conversation with the seller at all. And that could be a problem. And this is not a TREC issue. This is a what? Who takes care of this money? Who's this money for? IRS. Yeah, absolutely. Thanks, Kenny. So I don't know. I think I'd rather deal with TREC than that. Some of the other items that we have here, and again, all these are highlighted. They're in that handout that I have in the chat for you, so you can have that. Inspections, the buyer should accompany the inspector. It tells us that in the form. These forms, this is a general information notice to buyer and seller, was put together by Texas Realtors attorneys, which they have 9 of them up there now, right? Put together by them with input from brokers. So if this says the buyer should accompany the inspectors during the inspection, then I think the buyer should be there. I get pushback from that in some classes, but that's just a take on it. That doesn't mean they have to be there the entire time. I, as an agent, have always attended. I've always recommended attending, start, finish, the whole thing. It doesn't matter. Just make sure you touch base with them for sure. But it also says we do not have the skills to do the inspection ourselves, which I think is an important part for the buyer to understand. Making sure we do a walkthrough. Lately on some of the property, on some of the contracts, the agents are doing the walkthrough, but they're not marking any of the boxes. So they have the buyer sign it, but what are they signing for? I'm sure they're saying that they get a walkthrough, but there's no boxes marked. How do we know what's it applied to? And not trying to be negative or sarcastic with it, but if a buyer's signing blank forms, that's scary. Right? And every one of us have that capability because they trust us, right? And then MLS, the broker or agent provides information from MLS. And we've talked about this one in the past. One of the forms that we encourage you to use would be information from other sources. Information from other sources is a form we should be using. especially with a buyer. Information from other sources is a form we highly encourage you to use. And the reason for that is because MLS information and tax record information is not always correct. And that's exactly what this is saying, is we can only do so much. So if I was having this conversation with the buyer, I'd let them know this and let them know that I'm going to show them a form and we'll sign off on this as well, that you understand this. Talk to them about possession. And again, this is the general information notice to buyer and seller. This form is so important in my opinion. We've been using it for years, especially on the buyer side. Property insurance, make sure we touch base there and let them know they need to do that. They should be doing that before they find the property. Talk to the insurance. Make sure that they can get insurance. And just because somebody has money doesn't necessarily mean they can afford the insurance, because credit has an impact on some of that. And because that's one of the issues that we had here in Harlingen with a large property fell apart. A doctor was buying it, and right at the end, the agent did not have a conversation with him. And right at the end, when they went to get their insurance, it was extremely high and it blew them out. They couldn't make it work. And they ended up losing $2,000 in earnest money. We need to have that conversation up front, right? And there's a form, 2508 is a form you can use for that. The form for the walkthrough is a walkthrough form. That's what it's called, walkthrough. And you can actually make sure that form gets taken care of.
Is there a time frame to walk through that could be too early or too late?
That's a really good question, Patrick, and that goes back and forth from people.
Yeah.
Personally, I like 24 to 48 hours. But is that still going to guarantee everything's perfect? Nope. It really depends, because there's been 24 to 48 hours and the seller's still moving out. But at the same time, you don't want to wait till the morning of closing to go do the walkthrough either, because then if there's problems, we don't have time to react to it. And so
When we send our deals to submit for review, that it's going to be prep, but it's going to be blank because we haven't walked through yet. You know what I mean? I'm not going to send it to review the day before.
well, that's why you don't submit it. You don't submit it. Submit it when it's done. And that's why with zip forms, it works so much easier, because you can submit the one form. Like there's agents in Mission, there's several agents in Mission now that they submit the forms as they do them, not all one great big lump, 47 pages of PDF.
If you okay with that, submit them as we do them.
Yes, submit them as you do them. It works out so much easier for you guys. And day to day, that might on my end of day to day might be more, but it makes it easier at the end because you have everything together. As soon as it's done, do it. There's agents in Mission that'll do the information about broker services, listing agreement, seller's disclosure. I'll get that. They'll have that all in one package. And then when they get an offer in, we'll get that one. And they do the final paperwork, the CD, the funding form, all that stuff will be the final one. And I can go into the file and zip form and I see they have all these green clips already there. And here's 2 yellow ones. So I know I just need to check these 2 files. Everything else has been checked. Right? Where in dot loop, you don't have that. It's so much harder to work with. The property values, this is the paragraph, and that's the reason I put it in green. And again, if you print this, if you print it in color, or if you just save it as a PDF as a reference, I put that in green because that's one of the new parts. That was added this past year because of the property values, because we have people coming back to agents already saying, hey, you caused me to buy this property for more than what it's worth. It's your fault. I'm in this situation. I was at a class yesterday, and one of the individuals said that the buyer bought the property. They've had it for 6 months and they have to sell it. Now, fortunately, they've had it for 6 months and they're still going to make about $15,000 on this thing because of today's market. But a year from now, may not be the case. And in some places, that's not the case already. So that's why this paragraph was added in here. We need to actually talk to them about that. I would think every buyer should hear that from you, that property values fluctuate. We cannot guarantee what it's going to do in the future. Here's some others that I have highlighted on here. You can take those and use them the way you want. These are all paragraphs that I have highlighted are paragraphs that I would cover with a buyer in a minute. The reason for that is because of the experience with it. The sex offender site, we've only had one of those over the years where the individual came back and said, hey, I checked the website. I can't buy that house because the sex offender is right behind us. But that's all it takes is one, right? That if it's that important, we need to make sure it's there. Square footage, we have nothing to do with the square footage. We go by what's in the tax records or survey or appraisal or something of that nature. Surveillance, a seller might record, so that you're telling a buyer, right? The seller might record or otherwise electronically monitor a buyer without the buyer's consent or knowledge. Have that conversation with them to let them know about it. It's right there in the form. If you cover these items, you've done okay. The survey, the buyer needs to have a survey, and you want it as early in the form tells you that, as early in the transaction as possible, not the last 2 or 3 days, which is when it normally gets ordered if you leave it up to somebody else, right? We want to be aggressive with this, take care of our clients, make sure things go the way they're supposed to. And to do that, we have to follow some guidelines. And right there, it tells you in this form from Texas Realtors, buyers should obtain the survey. Speaking of that, though, let me also share with you that I've been told some of the title companies are telling the agents to order the survey. And I would be really careful about that. If I'm told to order the survey today, I would probably take some names and give them to the buyer and tell them to order it. I'm not going to order it. We've paid for surveys that we've ordered before. I won't do that again. So if normally the title companies that ordered it, the title companies we've used, but like I said, I've been told recently by some agents that the title company's telling them to order it. I would recommend you not do that. If you have a question about it, you can talk to one of the Normas or Nina or somebody else, but that's my opinion. I just would not do that. Tax prorations, we need it, especially new construction. We have a lot of new construction going on. And that's why I highlighted this one. When a buyer buys new construction, the taxes at closing are going to be based on land value only. It's right there in the form, so we can talk to them about it. It's right there in the form, so we can have that conversation. Land value only, and they will increase later because now we have a structure on it. That subdivision in West Harlingen over here, Vista Verde subdivision over by Wilson Road, that was one of the problems in there. Buyers were buying property $500 down. And then when they got the adjustment in their taxes, they couldn't afford it. They shouldn't have been buying the house to begin with. But
Mac, I have one thing to say.
Yeah.
On the, back up to the survey thing. We have to, surveys have gotten so expensive. I mean, they're like $500 now. So a lot of times on that, doing it early, it's really kind of a risky thing for the buyer, unless he knows for sure he's going to get that approval and everything else is going. It's a big outlay of money. So we have to be careful with that. I think ordering it early and encouraging them to do so. If it's a one given to us by a seller, we should have it during our option period for sure. But if
Right.
it's one he's got to buy, we have to all be aware. We need to make sure they're going to get this deal done.
Yes, ma'am. No, and I hear that a lot. I'll just tell you, I operate a little different, and I get that. And not everybody's going to agree with that, but in my mind, all of this should be done during the option period. All of it should be done during the option period. And I know that the buyer is going to have to pay for it, but when you're talking to the buyer about it, if there's a question as to should we do it or not, talk to the lender. If the lender says, oh, let's don't do that, let's wait till the end. I won't name any names, but I've actually looked at the lender and said, so are you telling me you don't think they're qualified? I mean, why are we waiting? So
Yeah,
I try to work.
What you're saying.
I try to work both of those, because if we don't get it and we wait till the end, then we have some problems. And we've had those. There was one in Mission just recently where there was issues with the survey. Those come up, and most of us, if you've been in business a while, you've had issues with them from one way or another. The sooner we get it done, the better off we are. But I do understand what you're saying as well.
I'm glad you explained it. I understand what you're saying better now too.
Right. So one of the other things was the termination option, and I highlighted in red for you. If you have an option, if the buyer has an option in there, we need to make sure that if we extend it, that we pay an extra fee. And it's not by choice. If there is a extension of the option period, there has to be a fee. And Trek has said $1 may not be sufficient. I'll show you that here in a minute as well. But that's why I highlighted it in red so it stands out. That's not an option, right? It needs to be paid. If there's no fee, that could cause a problem later on. And I'll show you the clip on that one so you have that to use as a reference when you're talking to other agents. Some of the other things, title insurance, buyer should always have a title policy. I know of no reason why a buyer wouldn't want one. Go ahead, Cody, did you have something? Okay, I'm gonna hit mute then. Utilities, the buyer needs to evaluate the utilities. It's their responsibility to make sure things are okay and that they don't have any issues with it. We'll do what we can to help them, but that's their responsibility. And then talk to them about wire fraud, and we beat that one up. Everybody knows how important wire fraud is, and it seems to be getting more and more important every day as we work on things. Be careful what you click on, because you don't know what it might be connected to. So if you're just running and gunning and you click on the wrong thing, you can end up with issues as well. And you want the buyer to make sure that they're okay. All right, so the inspector information form. This is the one that we want to give to the buyers. We actually recommend giving this to the buyer in advance, like during the counseling session, when you first talk to them, not if they called you on a sign and you're running out to meet them at the property, right? But when you actually sit down with them the first time and you actually have your counseling, this is the way it works, this is what we're doing. Go over this form with them. And again, I've highlighted some things in here for you to touch base on. And I'd also recommend that you have some things on the bottom here that you can use. Now, this is one of my old ones, but I've highlighted on the bottom to hire an inspector, not to hire an inspector. So when I give this to the buyer during the counseling session, what we've done over the years is we give it to them, talk to them, and oh, by the way, do you think you'll be doing an inspection? Yes or no? If they say no, we'll just make a note on this, right? Because it's a counseling session. But when they get ready to write the contract, then we do this one and have them mark a box. What's your choice? And have them sign off on it. If I present this to them during the counseling session, I also tell them and highly recommend, call the inspectors, find out which inspector you want to use, find out what their process is, and are they going to be available in the next few days? Or what is their availability? Because we're going to need to know that when we write up the contract, right? So let's get this ready to go. We don't want anything delaying our process. And the fact that the inspector can't get there does not automatically cause an option period to be extended. And by the way, there's no automatic extension, right? If the buyer wants to extend anything, is it automatic? No. The seller has to agree to it, and the seller can say no. And in today's market where there's backup offers, there's multiple offers to begin with, it's very possible the seller will say, no, I don't want to extend. And there's absolutely nothing the buyer can do about that other than push forward with what they have. There's a Trek, I don't know if any of you listened to it, the Trek coffee session they had here a couple weeks ago. There was a comment in there about buyers being advised not to do inspections. I hope that's not any of us. And they addressed it as well. That is not something we want to do. A buyer should always be advised to do an inspection for their own benefit. Even if the seller says, I'm not doing any repairs, we're still going to do an inspection. And we'll talk about that one a little more here in a second too. All right, next form is information about property insurance. And again, this is one of them that we probably want to include up front in the counseling session. We want to make sure the buyer understands that, especially if they're going to have financing, they're going to have insurance. If they're paying cash, that's their choice. But if it's financing, they're going to have it, and that's most of what we deal with. So one of the things they need to be told in the counseling session, go to your insurance person go to your insurance person, make sure they do homeowners insurance, and ask them if they can provide you a clue report on a property if you bring them an address. A clue report is like a credit report on a property. That's all it really is. It'll tell you whether there's ever been any claims or any of that stuff on the property. And if there was it paid and all that good stuff. A property owner can actually get the clue report themselves. So if you're on the listing side, they can actually get that report themselves if they wanted to, which might be a good thing to include with your uploaded documents in MLS. But please use this form. It's 2508. It's really, really important for buyers because they have to have insurance. We're in that time of the year. If there's a hurricane out there in the Gulf somewhere, you're not going to be able to close. So insurance needs to be in place before all that takes place. And that's always a factor we have to look at. Another form that we highly recommend is this one on hazards and deficiencies. This is one I joke around about it a lot, but it tells you the form number is 2504. And again, it's in that handout that I threw in the chat for you guys. I joke around about this one because it says that we build homes in Texas that don't meet the standards the way they're supposed to. So again, this is a notice. They don't need to sign it. They don't need to initial it. We can provide it to them, but this is another reason why they absolutely should get an inspection, because we can't guarantee how the home was built and all this other good stuff. Any questions? All right, take a drink of coffee. I'll do breath. Buyer tenant rep. On the buyer tenant rep, like I have here, verify driver's license, passport, all that good stuff. That's just basic information for them. Make sure you have the right information. Market area means we have to have a boundary. Coastal area doesn't work. And I don't remember what some of the others were I seen last week or this week. Market area needs to have boundaries. It can be a school, it can be a subdivision, it can be a city, it can be a county. South Texas doesn't work. Most of you are doing absolutely fantastic with that, but there's one area where that doesn't work. They plug in all kinds of off the wall stuff, but we'll work on that. Multiple listing service, right? So we are going to provide them information from MLS for sale by owners and builders. So on this buyer rep agreement, which is what everybody should be using, because this is, we no longer use the Remax one. On this one, it tells them that we are supposed to be providing them information about all these. I would not cross out any of these. You want to be able to work with that. Make sure that you have a time in here that ends on it. Work exclusively through the broker. If they meet another agent or they go to an open house, they're going to let them know that they're working with us, right? And they're swearing they're not represented by anybody else. Intermediary, you can talk to them about intermediary. Again, you'll have these. And for those of you that joined late, let me throw these in the chat one more time. So everybody has access to these handouts. All the highlights are on there for you so that you can have an opportunity to talk to them about it. These are all areas that we've seen. I say we've seen, I'm talking about looking at Trek Advisor issues with agents, not just in the company, but agents in general. Competing clients, especially today, you may have 2 or 3 buyers for the same property, so you might want to talk to them about it. What happens with that? Confidential information. A seller or seller's agent is not obligated to keep your offer confidential. Please make sure the buyers know that. A listing agent is not required to keep the information confidential, right? Especially if they have the seller's permission to share that. If I'm a listing agent and I get the seller to sign off on authorization to release, I can provide this information to the appraiser and I would encourage you to provide, if you have multiple offers, put it on an Excel spreadsheet and give that to the appraiser so they see what the other offers were that came in on that property. And that's part of that. It's confidential information normally, but we want to share it with the appraiser. If you have multiple offers and the seller's wanting you to go back and say, bring me the highest and best, get the seller's authorization to release so that you can put that out there with everybody and you don't have any problems with it. That form just covers us. Commission, folks, if you're not using this, we're probably going to have some additional classes on this part or discussions on it. There's some changes nationwide going on. There's a few I've seen here in the Valley, I've heard about here in the Valley, but buyers paying their own commission is going to be a thing in the future, I believe. So you might want to start thinking about how you're going to work that or how you're going to incorporate that into your presentation. There's brokerages. I was reading a thread this morning where it said MLS requires us to cooperate, offer compensation and cooperate, right? MLS requires that. So if I put a property in MLS, then we are supposed to share that. Well, the listing agreement tells what the seller and I have agreed upon, or the seller and the broker has agreed upon as far as what's being shared. The listing agreement does that. But if it goes in MLS, that's a unilateral agreement. Everybody's agreed that that's what's being offered. And it doesn't matter what it is. And the problem, the thread I was reading this morning, agents are going in and offering 1% to the buyer's agent. And in that thread, there were all kinds of comments, and please do not join any of these threads. In that thread, there were comments about how unfair that is. The agent should be fined. The board should do something. NAR should do something. It has nothing to do with any of those people. That's an agreement between the broker and the seller, period. Right? So please don't get into that mess. But know that you might want to start having conversations with buyers on how this is going to work. And we will work on that ourselves within the company. So the client will pay the broker the amount specified less than the amounts we receive. So if I put in a percentage up here, and they are only offering 1%, then the buyer is responsible for that. And there's ways to work around that so that they can still pay it and make it work, or whichever way you want to. Protection period, I'm not seeing too many issues with that. Normally we'll see 30 days in here, but if you have that in there and you really want to enforce it, you have to provide this on the buyer rep agreement. So you have to provide the buyer with within 10 days, a list of all the properties they've seen through you. And if they buy one of those properties, they still owe a commission. So that's just a real quick on the buyer rep agreement. Let me just throw out one other little thing here real quick, if I could. I should have highlighted this one. Right here at the bottom, that's not going to let me do that. Yeah. Right here at the bottom where it says broker's associate signature as an authorized agent of the broker, that's us. Right, so our name should be on the bottom. We should have this box right here where it says broker's associate's signature. You should have that marked, and we should be signing it. Broker's printed name should be Remax Elite. You have the license number there. We're good to go. And again, there's an office where I see the somebody else's name in there, not Remax Elite, not something like that. I see a person's name in there, and it's not the designated broker. So that could, if I provide that form to the client, and the client provides that form to Trek, that can be an issue, and we don't need that. That's why we try to clean all this up. Make sure we're okay with it. All right, so here's a 1 to 4 family contract. I actually filled one of these out for you so that you can actually see. And again, that's why that handout is so important. I keep trying to push that out there for you. I put things in here like verify tax records, show the name, right? We want to make sure that the name on the contract matches what we have on the tax records, and if not, why? What do we need to do, right? The buyer's name, driver's license, passport, or some other government ID. Lot and block. I actually see a lot of contracts come in that'll have lot and block 0, nothing in them. But over here, whereas this one says La Feria, they'll have La Feria, Bonita, lot 1, block 2. Well, lot 1, block 2 is supposed to go over here where the blank is, right? So that's simple stuff. That should have been pre-licensing things. And then for the address, it's address and zip code. Address and zip code. Exclusions, anything the seller's keeping from, to, B, or to C. Anything they're keeping in there. Anything that could be considered an improvement or an accessory that they're keeping. I think some of you might have been in the class when I showed one of these where they had any debris is going to be excluded. Well, I don't know how that ties in with it, but man. And then some of the others on here, unless I have it highlighted, I don't really, we haven't had any real issues with it. I do worry about this paragraph 4 because I'm not seeing anything there. And I know some of the properties have leases that are being bought and sold. And if there's a lease on the property and it's being bought or sold, we should have A marked and we should have the addendum recorded regarding leases attached to this. Paragraph 5, that's still a problem in one office, but we're working on that. And then it's the escrow agent, which is the title company, at this address. And that's the address of the title company, including the city and the zip code. And the reason I put that in there is because I see some of you put in capital title mission. Up here for the name of the title company, you'll say capital title mission. Well, if I put the address in, that's 2575 East Griffin Parkway, Mission, Texas, duh, that's capital title. And that's capital title and mission, right? That's the address. So that's the only reason I put that in there for you, so you can see that. And just fill it out the way it's supposed to be. And then earnest money and option fee, those two blanks, they are still getting mixed up by agents where they're putting earnest money in the option fee blank. And we don't want to do that. Title companies are, if I put earnest money in option fee, so I leave the first blank on the right blank, and I put that dollar amount in the option fee, title companies are receiving that as earnest money. And I'm not an attorney, but I think there would be some issues there on the contract. And we're the ones that's responsible for this, not the title company. Right? So we want to make sure that we have it filled out correctly.
Mac?
Termination option. Yes, ma'am.
I have a question about the option fee.
Yes, ma'am.
So now that it's paid to the title company,
Right.
I had a seller who's actually a broker in McAllen, but she referred her property for me to list and sell out here. But she says, when am I going to get the option money? And I said, well, the title company has it. You'll have to call them and ask them for it. And they said, no, they don't release it till closing. Is that true?
That's up to the title company. And the contract actually says that on 4, buyer authorizes the escrow agent to release and deliver the option fee to the seller at any time without further notice. And some of them do it at the beginning, but most of them wait till it's closed.
Well, isn't that up for debate though? I mean, if the seller wants it, shouldn't they just release it to her? Because they were supposed to get it, you know, in the old, before this, they got it right away.
Right, but that's not what this one says, and it also says that they're releasing the delivery of the option fee to the seller. So the option fee can go to the seller whenever the title company wants to. But I'm telling you, from what I've been told, some of the title companies will not do it until closing for whatever reason.
In some cases, I hear now in some of the other markets, the option fee can be pretty substantial in competitive situations. Some people are paying like $5,000 for an option, and they're holding it. Which, okay, all right. Just curious how that's supposed to work.
Yes, okay. And so that was one of the other changes, was the option fee is being credited to the sales price. So if a buyer, for those of you that caught that last part of that one, if the buyer is really confident they're going to buy this property, no ifs, ands, or buts, in other areas, they are encouraging them to put a higher option fee. And I've actually seen a couple that are higher than what was mentioned, which scares me to death, because if anything goes wrong, the buyer's lost that money. And we have actually had buyers come back and say, I want my option fee back. I didn't realize I was going to lose that $10,000. And that's not good. So please, yes, ma'am.
On that, I'm following up on what Norma just said. On that option fee, can they, like in a situation where it is competitive and they want the seller to get it right away, and we all know that doesn't, now we know that doesn't always happen. can that be added into special provisions? Can the buyer say in special provisions or the buyer's agent that option money is to be delivered to the seller within 3 days? I mean, can we put it in there and be specific, and the title company then has to follow that because special provisions takes precedent?
So you're gonna rewrite Trek's contract?
I'm gonna put it in there that they get it right away. I mean, yeah, I would do that in a heartbeat.
I would not do that. If the buyer is that adamant about having it done that way, or the seller, I would advise them to check with their attorney. That's what I would do. I would not write anything like that in there, because you're trying to change what the contract says, and we already have enough of those issues.
I never
Actually,
paid attention to that, though. This bothers me. I mean, that kind of bothers me, because the whole point of doing that is an incentive for the seller. Maybe the seller's needing money for something right now, and that's their incentive, is to get it right away. I think that's not a good thing.
Well, okay, so on Trek's website, and I really appreciate you seeing that, on Trek's website, they now have, and it's open right now, where you can go in and plug in comments. So before we had to actually email the general counsel, and now they have they've added this little block in there where you can go in and put your information in and put what you think about the contracts, and they will take that. That last revision, remember when we first started, I showed you, here's what they had in on the last revision where they changed paragraph 4 and 8 and all that. They had over 200 pages of comments or recommendations from agents and brokers, or consumers, because it's open to consumers as well. But in that Coffee with Track series that they had, Scott Kessler, he actually talked about that and how important that little block is to get our feedback on the contracts. If there's a problem somewhere, let them know so they can take a look at it. But that option fee has been an issue and will continue to be an issue. It was done this way because agents were dropping it off at the title company when it said it was supposed to go to the seller. The previous contract said it was supposed to go to the seller. And agents would drop it off at the title company and expect the title company to deliver it to the seller, or hold on to it until the seller comes by and gets it. That makes the title company responsible for it. And several of them would say they don't want to do it, and then the agent gets mad. Or I have a contract in McAllen with Norma down at South Padre, and I dropped the option fee off at McAllen at a title company, expecting her or the seller to drive from the island to McAllen to pick it up. And there was all kinds of complaints about that. And that's one of the reasons they went to this. To me, it makes a whole lot of sense. I don't see a problem with it, unless we are doing the 10,000 or 20,000, which I wouldn't recommend to begin with personally, but it does go toward the sales price. Just make sure the buyer knows what they're getting into. I had question marks in B here, and the reason for that is one of the things I am seeing is we'll have an option fee here, but no days down here on the bottom. And if you don't have days there, that paragraph says you don't have an option period. Yes, you paid for it, but you don't have any days, right? So, and again, I'm not an attorney to try to interpret that, but that would scare me if there's no days in there. And it has. Some of you seen those messages back to you. The title company here should match what's in paragraph 5A. So if I have Susie Jones delivered to Susie Jones as the escrow agent is the title company, not Susie, right? But if I have Susie Jones up here, I should have Susie Jones down here, which doesn't apply because Susie's not going to issue the title policy. The title company is going to issue the title policy. In fact, Susie's not even going to hold on to the money. I won't say anything else about that. Most of you that's in here are doing that the right way. The ones that aren't are the ones that messing up. On this one, I highlighted the survey. I've started for some reason seeing where individuals are marking the seller or the buyer, but they don't mark any boxes on the left-hand side. So I don't understand what we're trying to get at there. So it'll say survey 1, we don't have it, but we're going to get it within so many days, right? And that survey, if we're going to get it, it has to be with the T47. It tells us that right over here, right? Has to be with the T47. If they don't deliver the survey and the T47, then the buyer can obtain a new one, not later than 3 days prior to closing. Please don't wait till the day before closing, because then you're you don't do what the contract's saying either, right? And if that survey or the T47 is not acceptable, then the buyer or seller is going to order one, or the buyer or seller is going to pay for it. But what I'm seeing is none of these boxes, C1, 2, or 3 are marked, but we'll have buyer's expense over here on the side, and it doesn't say for what. And then on 6D, some of you've probably seen this note. 6D, we're not putting in activity. That's going pretty well. We're starting to leave that blank like we're supposed to. But we're not putting days in here either. And these are days to object to, the title commitment, exception documents, the survey. And if you have no days in there, then the buyer has no right to object to anything. So please put some days in there so we have that. All right, so there's some other highlighted items in here that might be of importance to you. This is the new public improvements district. And again, if you have something that's in a public improvement district, the only one I've found so far that actually says public improvement is Tres Lagos and McAllen. That is a public improvement, so you must have that addendum. Must. And it says seller. I had a question yesterday, who's supposed to provide this? Who's supposed to provide the new addendum? And the contract specifically says seller must give buyer. Seller must give buyer, right? So the seller needs to provide it. Seller's disclosure notice, we talked about those and how important they are. It's a Texas property code. It's not TREC. Texas Realtors or us. It's the property code. No, it needs to be delivered. If they don't get it, then they can get it, right? Within so many days. If they don't get it at all, they can terminate up until the time of closing. If they do get it within the, 5 days, then they have 7 days to actually terminate for any reason. It does not have to be anything on the seller's disclosure. They can wake up, they have 5 days, they get it on the 4th day, 3 days later, they wake up and go, I don't want the property anymore. They're out. So you just gave them an unpaid for option right there. And then D here, when we're talking about 7D, as is, they're buying the property as is. Every property, residential property in the state of Texas is purchased as is. When you write the contract, it's as is, unless you've seen something wrong. Unless you've seen something wrong. And then you can actually go in here and say the buyer accepts the property this way. What do you want the seller to repair based on the condition, right? And if there's any repairs or treatments or any of that stuff, we can put that in there. If it's something we know needs to be done, not if there's something to be done. And it says that right here, not subject to inspections. Do not insert anything like that. Residential service contract, please check the price. And if you're the buyer agent, order that. That's the only thing I will ever say to order. Check the price, talk to the buyer, make sure they're okay with it, and make sure that gets ordered. And then if you're involved in a contract and you're going to be the owner, the buyer, or whatever the paragraph says, there's 3 different options here on it. But if you're involved in it, please disclose that. Please, please, please disclose that. And it's closing on or before. Make sure we have that conversation with them on or before, especially on the listing side. What is closing and funding? We want to make sure we have that conversation. On special provisions, we don't use a if this, then that. If buyer finds termites, the seller's going to clean them up, right? That if this, then that type of thing. We don't use that. I will tell you that one of the things I've been seeing in here is the seller is responsible for making sure the lawn is freshly cut prior to closing. Well, what's prior? Are we talking just like Patrick's talking about? Do we do it the day before, the morning of, or 2 weeks before? Right? So more specific you are, if you're going to write material facts and business details in here, like that, make it as specific as possible, but not a if this, then that type thing. Settlement charges, yes, yes, ma'am.
I was in that. I try to tell other agents also, sorry, there's construction going on in my house, but anyway, seller will this, but seller will do this and seller will do that. And that's pretty much, you can't go wrong if you just say, this is what he's gonna do, right?
Yes, ma'am. Absolutely. Thank you.
Mhm.
Just make it a statement, not a if this and that. Paragraph 15 and 18 are the two paragraphs I always tell agents, tell your client to go back and read. Client says they want to do this. I want to terminate the contract. I want to get out of the contract. I've changed my mind or whatever it is. Please go back and read paragraph 15 and 18. And on 18, what you might want to look at is paragraph C and D to go with that. So for example, on D, if I submit a termination notice and release of earnest money as a buyer's agent to you as the listing agent, and your seller says, I'm not going to sign it, any party who wrongfully fails or refuses to sign within 7 days, right? This is if we go through the demand part of it, but if they refuse to do that, they could be liable. We don't need to put them in that. So that's why I say, tell the parties to go back and read that. And that usually, I've always found that helps eliminate some of the anger they may have, is to know that they could be held responsible for it. Of course, you're always going to have somebody that says, I don't care. That's going to happen from time to time. And then I highlighted 18E for notices, because notices will be effective when sent in compliance with paragraph 21. Paragraph 21 is the one that has the notices here where we put the buyer and seller's information in here. And please put their information in there, not yours. If you put your information in here for notices and you get the notice and you don't relate it to your client and there's a timeline involved with it, you're going to be responsible for it. So always put their information in there. There is an agent in Corpus. She puts all of her clients' information in there, but she also includes her email address. And I know in Corpus Christi, one of the practices they used to have when I taught a class up there before was they were telling agents to do that because all notices are going to be sent there. And I want to make sure I get a copy of it. Most agents are going to deliver notices to another agent. I mean, I've never seen that not happen, but each area seems to have their own little practice, which might be a little different than others. I skipped over 20, and that's again, foreign person. We had that in the contract. If the seller's a foreign person, we should be talking about that on the listing side. We should make sure if we're the buyer's agent that we're good to go. We don't have any problems. This is what I was referring to. If the seller fails to deliver the affidavit, right, to the buyer that the seller's not, then the buyer shall withhold. The buyer shall withhold. And that's what I was getting at. The buyer's going to be the one that's responsible for it. And that's where, if we're the buyer's agent, could pick up some liability with that one. Any questions on this one? One last little bit on this one. And then I have some slides I want to show you just real quick. On this page, this is the ratification page, is what it's referred to as. If you're in this class and you have a listing, you would be on the right-hand side, and the listing broker firm would be Remax Elite. If I have a buyer, I would be on the right-hand side for your listing. I would be on the right-hand side. I would be on the right-hand side for the on the buyer side, and we would have intermediary, probably, but not guaranteed. To have intermediary, we have to have a buyer rep agreement and a listing agreement. You don't create those when you write the contract. They should have been created a long time ago, not when you write the contract. If I don't have a buyer rep, but I've been working with the buyer, then we both still be on the right-hand side, and it'd be seller only as seller's agent. Because just this past week, again, we had listing agent on the right-hand side from Remax, buyer on the left-hand side from Remax, buyer's agent on the left-hand side. And that's not the way this is designed. If you're representing the buyer and the listing agent is representing the seller, it is intermediary, if there's representation, which is what they have marked. This bottom paragraph right here, for some of you, please note, this just recently become an issue. with one of the agents out of Mission. If I'm writing an offer up on a property that's listed by somebody else, I have to put a percentage in here. Now, in the past, we've always said that's not a big deal, right? We're gonna go by what MLS has. However, times change, right? We're negotiating multiple offers. And I could be off just a little bit on this, but my understanding was the seller said, or the listing agent said, the seller accepted your offer. The seller accepted your offer because there was no commission in here, and we assumed you didn't want anything. So that's the reason your offer got accepted. They thought they were going to be able to save some money. So we're not set to pay that commission. And that's a problem. Now that to add to that, so you understand that's not the norm. For those of you that's fairly new at this, the agent is a part of the company that was buying it. That was part of the company that was buying the property. So they're saying, assuming since they're buying it, they're willing to give up the commission, right? Which to me makes some sense, but I would have certainly asked about it. But she said she completely forgot to put the commission in there and was asking about it. Both myself and Norma, I talked to her about it. Norma made some phone calls, and they're not going to pay. So just keep that in mind. If you're working with another office, you need to put something in here so that we don't have any issues, especially if you're doing the purchasing. One of the other areas that we have, the title company should be writing times in here, and sometimes they're not. So we want to make sure that they do that. That time becomes really important if the seller decides they want to terminate. If you're using zip forms, this addendum that you see here in front of you will be automatically created when you type more than what the space is designed to hold, or you can click on the paper clip right above the document, and it'll add it automatically for you as well. And then the consumers can sign it at the bottom. So then you have documentation on it. You don't need to do it. And if you notice, that was already in that paragraph at the beginning here. And that's exactly the way it'll show up on yours if you'll use that addendum. I'm sorry, if you're using zip forms and use that addendum. Right. I forget which one it was now. Anyway, it shows up on the paragraph as well. That addendum is being used. Right there it is. See addendum, right? And so when you create that, it's going to show up in the writing for you like that. It'll say see addendum. And the addendum it's talking about is that last page. That automatically gets created in zip forms, or you can click on the paper clip right above the document and put that in there for us. Any questions about any of those items?
I got one question or on that, what you were saying, because you had brought that up at a meeting at our office, was that the seller decided they weren't going to pay because she didn't put the commission in there. My question is if they had she was representing herself in that, Mac, that was them representing themselves.
She's representing the company which she owned part of. Yes.
If that had been a regular contract and she had a buyer's representation agreement and there was a 3% mark, they had filled it out and asked for 3% from the buyer, and then they made that mistake, could they go back to the buyer and get their 3%?
Sure. Okay. I would say sure, but I would think they could without any problems. But all right, I just have some couple little things I want to show you, and then we'll wrap this thing up. On the contract, there's that block there that says will amend or will not amend. And I've shared this in the past, but when we talk about amending, so first off, we need to have a survey, right? Because that's what it's going to be based on. And let me just share this slides with you here on it. It's going to be based on what the survey is. And so if they're going to amend or not, that's a decision they need to make. But I wanted to show you this because they will not, if it's marked no, they're not going to insure against any kind of a loss that's created because of any of these items, right? And that's why it has been the recommendation I've been throwing out for the last year here is mark yes and let them know that it's important, because if there's anything wrong, we get the survey and there's an encroachment. If it costs to get that fixed, it's going to be all up to the buyer. Seller, the title company is not taking any responsibility for it. That's what marking no on that does to you. And again, this may be something you need to share with the other agent. So these are, I'm going to upload all these in the Facebook group and et cetera for you guys, so you have them as well. Here's what that costs. When we talk about the T47, so they're using an existing survey on that amendment. Let's say that we say that they are going to amend it. It's 5% of the title policy. 5% of the title policy for residential, right? So if you're looking at a $500,000 sales price, the title policy is $3,091. You're talking about $154 to make sure that everything's covered if anything goes wrong there. I think that's pretty valuable. And it states, and these, by the way, these clips came out of Texas Realtors. Legal Frequently Asked Questions is where I got them from. If you mark will not amend, make sure you have a conversation. It says extensive conversation with the buyer so they understand why that's being declined and what to expect if anything goes wrong. Because otherwise, guess whose door they're going to knock on, right? We don't want to be that one. Also, this, when we talk about seller's disclosure, I get questions about that. Is it needed for this? Is it needed for that? Here's a list of reasons why a seller's disclosure would not be needed. And this is actually in some of the Facebook groups already, but I'll put all of these in there today. So you guys have them and you can take a look at them as well. And use them as a source for other agents. Part of our job, fortunately or unfortunately, is to educate the others. Can a buyer's agent just mail the option check to the seller? Now, this is from the old system, but it still applies. Can we just mail it to the title company? And no, because it has to be delivered within a certain amount of time. Will the buyer have to pay another option fee for an extension? And we talked about that one already today, and the answer is yes. And down here on the bottom, in this very last sentence here, extensive law, case law, suggests that the termination option period cannot be extended without an additional option fee. So that tells me it's not optional. That's the way I read that. There has to be a fee attached to it. And again, on Trek's website, it says $1 is not sufficient. Make it $5, make it 10, but pay something of value. On the last day of the buyer's option period, the buyer and seller still negotiating repairs. What do we need to do? You can't do, even if it's the seller that's dragging their feet on this thing and we need to extend the option period, the buyer's going to need to pay to get that taken care of, right? And the last one is on intermediary, because we do have some issues all the way across the board with intermediary. Number 5 down here, what happens if an unrepresented buyer wants to buy one of my or my broker's listings is a big part of that. And that's when I made reference to the buyer rep earlier, and I said that it needs to be from the beginning, not when I'm writing up contracts. That's what I see is the buyer decides to buy one of our listings, and agents are under the mindset that, well, they're buying one of RE/MAX's listings, so I need to do a buyer rep agreement. And you can look at the dates on the contracts. I can look at them and see that there's a difference. And me not being an attorney, if I can see that, I'm sure somebody else could probably take a look at that as well. And we just want to do what's right. Just want to do what's right. So if you're representing the buyer, okay. If not, can I still write up the offer? Yes. Yes, I can still write up the offer. But remember, if I'm not representing that buyer, as number 5 says, it's an unrepresented buyer, I cannot give them advice and opinions. I cannot give them advice and opinions. If you have intermediary, and there's an agent I wish was in here today. I absolutely wish she was in here. If you have intermediary where you're representing both the buyer and seller, you cannot give either one of them any advice or opinions, period. And I get that you want both sides of the $600,000 transaction, but we need to make sure that we're doing it the right way. And it's not just you, it's Remax Lead, it's Norman Hinojosa. You're throwing under the bus when you do this stuff. We don't need to do that. Anybody have any questions on the representation part of this? All right. Well, I do appreciate everybody being here today. If you know somebody that missed this one, like there's an individual that missed the last 4 and swears it was my fault. We have another one on Tuesday at 1 o'clock. And it'll be a lot better than this because I know by Tuesday I'll be all fired up. Today I'm tired. Anybody have any questions or comments?
I have a comment, Mac. I have done this. Well, you know, I've been under just 4 brokers, but this is a really good class. You covered things on a basic contract that I had never heard, and it sort of put things in a different perspective, and I appreciate it. I think you do a great job.
Thanks, Candy. Appreciate it. Anybody else? All right. If not, I appreciate you guys' time. We should have everybody had to register for this class, right?
Thank you, Mac.
Everybody had to register for the class, so we have the roster from Zoom. I should be able to pull the roster from there as to everybody that attended, so we should be good to go. I do wish you all the best. If you have anything, give me a yell. It is a holiday weekend, so be safe out there. And if you need anything, we will be around. All right. You guys take care.
Thank you, Mac.
Yes, ma'am. Thanks, Karen. Thanks for using zip forms. I appreciate it. There's only 2 of you in Corpus that are using zip forms right now. It's just unbelievable. Yeah. Yeah, well, I thought so too. And there's others that are starting to do the same old thing where they upload 47 contracts, 47 forms as one, which is just ridiculous. But I do appreciate everything you're doing out there. You're muted. I can't hear you.
Okay, is that better?
Yes, ma'am.
Okay, great. If both agents are in the same office, that part down at the bottom about the commission, you would leave it blank, right?
Absolutely. Yes,
Because
ma'am.
it says other agent pays. Okay, that's what I
Right.
thought.
Yes,
And I
ma'am.
had the title company do the HUD and they didn't pay any commission.